cash damages is the only thing you can get. Of course, I mean, I would prefer, it's just from someone who's been involved in an accident, you would prefer your good health as opposed to getting money for your back injury or for your neck injury. I mean, nothing's going to restore that back. Unfortunately, the way the system is set up, his money's the only thing that you can get.
He wasn't in any auto crash. He didn't slip and fall. Still, he's suing, looking for cash compensation for the personal injury he says he suffered. Torts, uncommon and other, on the docket this week for Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
More than 1 million cases each year filed in state courts nationwide. 60% of those filings in just 5 states, and New Jersey is among them. So it's no wonder that so-called tort reform has swept the state and the country. I'm Ray Brown, and on this edition of Due Process, we take on torts. We'll talk to 2 experts in the field. One, a lawyer who brings claims on behalf of clients he says have suffered personal injury. The other, an attorney who contests them. But in case you still think it's all slip and fall or car crash, Sandra King is here with one example that just might change your mind.
Ray, it's a case of some pre-Christmas shopping at one of the country's most upscale malls. And the shopper wasn't any ordinary citizen. He'd been fire director and police director in New Jersey's largest city, where he still does public service as a municipal court judge. But none of that was enough to keep Claude Coleman safe when someone decided, in what was later described as a case of mistaken identity, that he had tried to pass some bad plastic in Bloomingdale's Short Hills.
My life has become defined by that particular week. It seems like now I'm the judge who got arrested in Bloomingdale's. It's not the former police director, the former fire director, it's not the former police advisor to the police department. No matter what your achievements have been, they are all overshadowed by the fact that I was arrested that weekend.
Claude Coleman calls it his nightmare week. It began 2 years ago in Bloomingdale's, just 14 days before Christmas, when this municipal court judge went on what should have been a routine shopping trip. By the end of that week, there was a formal apology, an acknowledgement that the judge was simply a customer who became an innocent victim. But in between, there was an arrest.
I had no idea what was happening. They came, they surrounded me. They pushed me against the wall, get against the wall.
There was what Coleman claims was abuse, both by Bloomingdale security and the Millburn police.
By denying me the right to go to the bathroom, by denying me the right to call an attorney, I was handcuffed to the wall there.
There were the repercussions that came at work.
That Monday, I was suspended from practice here. Of course, I could not go back on the bench because I was supposed to appear in municipal court in Millburn on the Monday morning. And so I could not hear cases.
And those felt at home.
It's been broadcast, and it's like every half hour on the hour, nationwide broadcast on WCBS radio.
And the shockwaves traveled throughout this city, where Claude Coleman, who had started out as a cop, came to run the state's largest fire department, then police department, landing finally on Newark's municipal bench. So Coleman says if any black man should have been safe in an upscale suburban shopping mall, it should have been he.
It is frightening, too, to think that it could be done to someone so easily. And to think, too, that they would fabricate the statements that they made and attempt to fabricate the evidence and to withhold basic constitutional rights from you on a whim.
And he's convinced that his color made all the difference when those security guards grabbed him based, Coleman says, on this description.
Light complexion.
No beard.
No beard. I believe he was wearing a hat. I had no hat. And I don't think this would have happened to anyone. I don't think a white municipal court judge or a white police chief would have been arrested or treated in the same manner that I was, without any evidence whatsoever.
The damage, he says, began that day and continues through this day. Apologies notwithstanding.
These are like genies in the bottle. I mean, once the genie is out of the bottle, it's hard to put it back. And an apology coming from a representative of Bloomingdale's, why I appreciate it, just didn't do much to restore the reputation that it had before that. There's always people who believe, just as they believed that Sunday morning, that there was something to this, that there had to be something to this for the police to have acted in the manner that they did. And so in that way, I think my reputation has been indelibly tarnished. And I'm not sure whether it will ever be the same again.
So this is no ordinary personal injury suit, but Coleman is suing and looking for cash damages.
Cash damages is the only thing you can get. Of course, I mean, I would prefer, it's just someone who's been involved in an accident, you would prefer your good health as opposed to getting money for your back injury or for your neck injury. I mean, nothing's going to restore that back. Unfortunately, the way the system is set up, is money's the only thing that you can get. And it's the only thing, too, that will make Bloomingdale's kind of take notice and perhaps stop this kind of action or this kind of behavior.
We did ask for comment from Bloomingdale's, the Short Hills Mall, and the Millburn Police. There was none, and Claude Coleman's case is set to come to trial next month. But if it makes it to a jury, it will be one of the few personal injury cases that ever does. Well over 90% are thrown out or not pursued, or most commonly disposed of through settlement. Of course, most of these are auto accidents or premises liability or malpractice. Next to none, Ray, is quite like the Coleman case.
It'll be interesting to see whether the system handles this unusual case the way it handles what we come to think of as more usual kinds of cases.
And even this one has not yet gone to a jury. I would imagine a settlement, as you know, is always possible.
And when we come back, we'll explore the questions and controversies that still surround personal injury, even after tort reform, with two experts who sit on opposite sides of the courtroom as claims of injury are argued for and against. So stay with us.
Could be anything, I guess. You could fall down here and have a personal injury suit against the mall.
It's a suit, I guess, when you're taking action against another party because of some type of damages.
A personal injury suit is when somebody's injured by another person's property or within the vicinity due to neglect.
It's somebody else's fault for you getting injured.
If you're on a bus and the bus is in an accident, that's a personal injury suit?
If you get hurt, you could sue with the city or whatever you want to sue. Even police officer.
They remain the most controversial area of civil law. We're told they're what drives up the cost of auto insurance and even medical care, thanks to the exorbitant price of malpractice insurance. So it's no wonder that all 50 states, each with its own array of laws and negligence and liability, have adopted some type of tort reform in just the last 10 years. And two men are with me who know their way around all of that. In fact, there may be no one who knows more about representing the plaintiff than Harold Sherman, who, by the way, is the president of the New Jersey Bar Association, and no one who has more effectively defended personal injury claims than Richard Amdur. And we've also learned that it seems that 30 years ago, they tried their first cases against each other. Harold, let me ask you a question.
Sure.
We've seen a package involving a man named Claude Coleman and what sounds like a defamation claim, injury to his reputation. Most people, when they hear the word personal injury, tend to think of broken bones or perhaps medical malpractice cases. How common is it for there to be personal injury cases not involving broken bones and claims against doctors?
Well, I think they are not in the majority, but they're certainly more common than the average person would relate to because they think of an automobile case or a slip and fall as the title of your program.
What are the more common kinds of other cases besides
well,
the ones we used?
there are a whole series of non-physical damages. There are the defamation cases, the false arrest cases, and in recent years there have been new areas of the law that have opened up. Sexual harassment suits, emotional...
Age discrimination.
That one is certainly one that I'm interested in.
Do they present new challenges to the court system, or are they handled pretty much as other cases were?
I think they're new challenges. They're new theories, new claims, new defenses, and but if your trial lawyers handle them as trials, you know, it's just a different claim, different defense.
Let me ask you a question about about this package involving Claude Coleman. Coleman is a man who was a municipal court judge, and his defamation claim obviously is in terms of the damage to his reputation as a lawyer and as a judge. Assume for the moment, on the other hand, that this had happened to a man who was wearing coveralls, who was a working man, who maybe even a guy who as a younger man might have had a record for some minor problem with the law. Would that change the nature of the possible damages? Would a lawyer even take a case like that?
Well, whether he would take the particular case would depend on all the facts, but it's interesting that you say that because people like to think of equality under the law, but another way to look at it is that in this type of case, the higher the reputation, the greater the potential damage. I don't know how many people know that gentleman who works in the coveralls, his immediate family, his co-workers, people all over the city of Newark and over the state, perhaps know Judge Coleman. So the potential harm to him is much greater. And not that he's worth more as a person.
That's true. Looking at it from the standpoint of the store, the mall, the police, if they're dealing with somebody who is in coveralls, as you say, or whatever everyday type of job, the exposure to the store, to the police, to the town is much greater with somebody who has much more of a reputation, that is much more in the center of the public eye.
So this is one way in which the system tends to favor the powerful and the well-positioned over ordinary working people.
I don't think it favors them because I think the harm to them is greater. Much as I hate to agree with Richard and he with me, we apparently agree on that issue, so we better talk about something else.
Well, there are a couple of the things we wanted to talk about. One of the things is that there's a popular perception that plaintiffs' lawyers are ambulance chasers, that they'll go all over the universe and unscrupulously go after cases where they have no business doing it.
Right. There are good lawyers and bad lawyers, just like there are good butchers and bad butchers, good bakers.
Some lawyers are butchers.
Good bakers and bad bakers. There's a percentage in any business or profession.
But what happens is, for example, the legislature and the governor get caught up and we may have legislation. For example, just last week there was a terrible accident in the Andes, and within a couple of days there were front page stories in the local New Jersey papers about lawyers flying from here to there to the Andes unbidden, holding press conferences on behalf of clients that hadn't hired them.
That's reprehensible, it's condemned, it's not proper, and it's unethical.
Let me tell you this, there are such a small number of lawyers who would do a thing like that, and they get all the publicity. The State Bar Association just entered into a compact recently, unprecedented, other states are copying it, with the Red Cross, whereby we supply volunteers to go to disaster scenes who are licensed, who are trained, who wear a Red Cross hard hat, and who will not undertake a case for their own benefit, nor refer one to anyone else, nor take any money for giving the basic advice to people dazed by some terrible disaster. And this is the kind of thing that the majority of the profession does.
Why do you think the popular perception is so much the contrary then?
Well, because as Harold says, there are a few bad apples in every bunch, and the bad apples are the ones who get the publicity and make the bad name for the legal profession. Incidentally, there's legislation which has either been just passed or is about to be passed, which forbids attorneys and others from contacting an injured person, from making the contact within 30 days of the injury. That doesn't prevent the injured person from contacting, in that case, the lawyer.
But actually our rules of conduct have prohibited, in theory, lawyers from reaching out to people when they're vulnerable even before this.
The lawyers that you read about, as you say, that make the bad publicity for the profession, if there are round figures, if there are 50,000 lawyers in this state, all it takes is a few to get in the newspaper to do something wrong that tarnish the legal profession. There are lawyers out there who are doing work for free, so many, as you know, and as Harold knows, pro bono work. They don't get the publicity. It's the ones that make the bad name for the legal profession.
Ray, you asked about the public perception. Have you ever seen a headline that said, Richard Amdur, a very good lawyer, did good work today in his office and on his way to court? and in court. Did you ever hear a story like that?
Well,
that's not very exciting.
Let me look at it from another point of view, though. It does seem that much legislation, for example, some of the debate about tort reform was fueled in part by the perception that lawyers have some incentive to phony up or bring frivolous cases.
Oh,
Isn't that part of why why is the attack on the contingency take place?
I think it's to discourage the claims. I think the overriding interest of those who advocate that sort of thing, and usually it's the 1,000 Fortune corporations, it's the insurance companies, is entirely apart from the lawyer or the lawyer's alleged avarice. It has to do with their own economic interests and with various ways of depressing their exposure and their cost of doing business. That's what it's all about.
I think another thing is the prevalence of gambling. It's the lottery concept. Don't forget, if you have lawyers who are bringing groundless claims, you have to have the litigant who's there and who goes to the lawyer or who is contacted and agrees to bring these so-called worthless or groundless claims. But the legislation, and in fact it's the juries who can discourage these groundless claims by constantly throwing them out.
So you're comfortable that the jury system itself weeds out the wheat from the chaff and there isn't a need for additional legislation?
I think that 98% of the time the juries do the right thing and do weed out the groundless claims.
Let me ask you a question about the contingent fee, because it does seem to be a lightning rod for debate.
Before we leave that, one more thought. As Harold said, you read about the $1 million verdicts in the paper, the $2 million verdicts. You don't read about all the cases that are thrown out where people don't get anything.
Well,
and
actually,
that is the largest.
We read a lot in the last few months about a case that you were involved in Kenilworth.
Yes.
And it's a case that maybe we ought to talk about a little bit. It was a man who had, on 2 previous trials, was a quadriplegic, had gotten sizable verdicts, $8 million in one, I think 6 in another.
He got $8.4 million the first trial. That was reversed on appeal on legal grounds, came back. There was a second trial. He got $16.1 million. Those were different attorneys, different trials.
And on the third trial, in which you represented the town, what was the verdict in that case?
It was the borough of Kenilworth, and the verdict was $3 million.
Now, that was a case in which it certainly could be said fairly that you saved the township significant amounts of money. But let me ask you a question that occurs, which is, this was a man who was a quadriplegic, and essentially your argument was he hadn't done enough to go out and educate himself and get himself retrained to survive in the market.
That he hadn't done anything to improve himself in any way to make his life better.
Some folks might think that's a bit harsh. Is that something that you felt comfortable with, and how do you feel about it?
I felt comfortable with it because it was the truth. He had done nothing to educate himself when education was available to him for next to nothing or for nothing. He had done nothing to go about improving his physical self and his lifestyle when all of it was available to him. He hadn't, there are jobs that quadriplegics can do. He had done nothing. So I felt comfortable with that being the truth.
So very important in your work is to know that what you're saying has some basis in reality.
I think you have to have credibility and believe in what you're saying, like anybody that's selling anything else, because a lawyer with a jury is selling himself and his product, and if you don't believe in it, you can't sell it.
You know, that concept may sound harsh, but there is a concept called mitigation of damages. That is, the injured person. And bear in mind that these personal injury suits, and there are defenses against frivolous suits and burdens of frivolous suits, and the contingency of the fee itself weeds out a number of cases that would be frivolous. The concept is that you must do what you can to reduce the amount of damages even though you were injured as a result of the negligence of somebody else. For example, if an operation that's relatively safe would greatly reduce your pain and suffering and your disability, you don't want to have it, that is a burden that you have to begin to share.
But sometimes this involves some very nice and difficult calculations. For example, the young man in your case had rejected a settlement offer of 6 or somewhat more than the money he got.
It was more than the money he got. Before we leave that thought, I do want to make it clear that I had an advantage that the lawyers did not have who tried the first 2 cases. I had the advantage of reviewing all that they had done in those 2 trials, so I want to be fair to them. I had an advantage they didn't have.
Right. Let me
put it to you this way, if I can. Sure. Richard doesn't put it quite as directly. All the mistakes that could possibly have been made in that case were made in the first 2 trials, so there weren't any left over for him.
But I guess the question about settlement suggests that even you thought it was probably worth more in terms of settlement than a jury ultimately decided.
Well, you never know what a jury's going to do, and so you try to be cautious for your client, and you can't evaluate a case as perfectly maybe as somebody who's looking at it in hindsight.
Now, let me take you back then to the contrast between a case in which when a person loses the ability to move his body, we have a good, tangible sense of what the loss is, to a case like the one we saw in the package with Claude Coleman, where the damage is to reputation, which is harder to touch and feel.
Difficult.
Is it harder to resolve by settlement, which is the objective of the system, a case like this one, than it is a case?
Judging from what I saw of that, it will be difficult to settle that case because I don't know that the person who's bringing it wants to settle the case. However, it may be different when he gets to trial, but that may be a difficult case to evaluate because how can you evaluate the damage to his reputation? It'll be just as difficult for a jury to evaluate.
The first factor that, and I don't think there are any broad general rules on what's easier to settle than something else. The first factor in each case, on a case-by-case basis, is the liability, the responsibility, the chances of winning or losing, the problems. The second factor is the personalities. In the case, some clients are afraid to go to court and want to settle at any price that's offered. Others do not want to settle at all. Maybe Judge Coleman, for example, might want the vindication of a trial. I don't know.
Now, Harold raises a good point. What we don't know is why...
Why didn't you ever say that to me in court?
Well, because I don't want to make you happy in court.
But was it ever true?
It's never been true before. This is the first time it's ever been true. But what we don't know about that case, about Short Hills and Milburn and the mall, is why it happened. Maybe there's a very good reason why it happened, because the conduct of the police, the conduct of the mall, the conduct of the town has to be reasonable, and I'm sure there's an explanation.
Spoken like a true defense lawyer.
Well, that was Judge Coleman's point, that it will have the appearance of, well, gee, there must have been some reason for them to act in such an extreme manner.
What about his statement, which in some ways says the system is too narrow, that no amount of money, or except perhaps symbolically, can get him his reputation, that he'll always be known as the judge who got arrested at Short Hills?
Well, that's always true, even in an injury case. But let me say this. The concept of, oh, you know, money doesn't do it, the concept replaces the old biblical injunction of an eye for an eye. It is very civilized to give people money to help them. It never fully redresses. Certainly it doesn't redress the death of a loved one, no matter how much it is, but it's what we have to offer to at least acknowledge the fault and responsibility and acknowledge that there's been harm and damage and that society wants to try to soften that.
Now,
That's all it does.
I can't have the two of you here and not ask you this question. The next time the public or the governor or the legislature gets excited and we have another tort reform argument, is there anything that either of you thinks should be done or undone in terms of how the system functions now? Because you know there will be more tort reform discussion. Whether it's next year or 2 years or 4 years or a Democrat or Republican administration?
I think that the legislation that's been passed now, the most recent legislation, doesn't have any teeth to it and will have very little impact on the litigation. For example, the medical malpractice so-called reform. It requires that you get an expert who will, before you bring a suit or within a certain number of days you're bringing a suit. That's done anyway.
You couldn't get to a jury, you couldn't get a trial without
that's not going to have any
before.
impact.
Okay. So it was largely smoke and mirrors?
I don't know about smoke and mirrors, but I think it's ineffective. I haven't seen anything that's been passed. There's a cap on punitive damages. That will probably help to some extent, but punitive damage cases are such a very tiny percent of the litigation anyway.
But loom large on the political landscape because they've been talked about in the public arena.
Those types of cases generally touch the huge corporations who are allegedly with full knowledge of the risk or danger of some product and don't disclose it or don't correct it or cure it or modify it if possible.
Well, would you favor any additional tort reform? Or?
Yes, I would. I think that what Richard is referring to in the medical malpractice field is a certificate of merit before the suit is filed, and that is another impediment, another expense, and another burden for plaintiffs, and probably the most expensive.
So you would roll back part of what's been called tort reform?
I would definitely roll that back, and to put caps on punitive damages, which are designed to deter and to punish, not to destroy. is absolutely contradictory to the entire concept.
Ray, the only thing that will reduce groundless litigation will be if the person who brings it has to pay something in the way of counsel fees for the party. I know he doesn't like that.
How do you feel about that? We're winding down.
I am glad we got to that. Let me give you the catchphrase.
Let me make a quick response.
The catchphrase is loser pay. That sounds great. Here are two people on a level playing field, two individuals, Joe and Fred, are on the level, and somebody is brought into court.
The small guy can't afford
and
it.
the loser. But that is an absurdity because of two reasons. It's the English system, people say. Well, the English system
You got to say this real quick.
Provides a lot of relief in other areas, but more importantly, 95% of injury litigation is defended by insurance carriers or large corporations to whom this means nothing. The only deterrence here is to the plaintiff.
This is great discussion. It means I'll have to bring you back so we can find out who won that case 30 years ago. I want to thank you both for being with us.
Thank you.
That's it for this edition of Due Process. We'll be back next week when we look for answers to a question I've been asked for years. In fact, it's the question put to all criminal defense attorneys. How could you represent him? Some straight answers next time. Till then, for Due Process, I'm Ray Brown.
It's not the former police director, the former fire director, it's not the former police advisor to the police department. No matter what your achievements have been, they are all overshadowed by the fact that I was arrested that weekend. And there's always people who believe, just as they believed that Sunday morning, that there was something to this, that there had to be something to this for the police to have acted in the manner that they did. And so in that way, I think my reputation has been indelibly tarnished. And I'm not sure whether it will ever be the same again. Hopefully it will, but you can never be sure about that. I just don't think it will be.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.